So much is going on in the Fani Willis saga. And now the Nathan Wade and Jocelyn Wade saga. King Channel TV has the latest to date to share with all of you. But first, please click that like button, share the video and subscribe to King Channel TV, and click that notification bell to be notified of new information. There were 3 new developments that happened this morning that will move this case closer to the next level. The level of knowing the truth. First, the Fulton County Board of Commissioners, the BOC, has responded. For those who do not know who or what the purpose of the BOC is, watch our video. Georgia Governor Brian Kemp signs SB 92, the law with power to remove DAs and prosecutors. Second, Cobb County Superior Court Judge Henry Thompson ordered the divorce case unsealed. Third, the judge also did not grant Willis her motion for protection. We will briefly detail these new developments. Commissioner Bob Ellis wrote Willis, "As the chair of the Fulton County Audit Committee, I must reasonably inquire about allegations that are contained in a recent court filing, asserting that you misused county funds and accepted valuable gifts and personal benefits from a contractor who is a recipient of county funds." He also wrote, "These allegations involve your decision to appoint Nathan Wade as a special prosecutor in the matter in which former President Trump is a co-defendant. Mr. Wade is alleged to 1. Lack relevant prosecutorial experience in a case of this type and complexity, 2. Have paid for your portion of multiple instances of joint leisure travel, and 3. Be in a romantic relationship with you that was not disclosed to the court or to the parties in this case. Separate from any particular requirement by the state of Georgia, this situation requires confirmation of whether county funds provided for the operation of your office and its prosecutorial function were used in an appropriate manner, and whether any payments of county funds to Mr. Wade were converted to your personal gain in the form of subsidized travel and other gifts." The commissioner further required Willis to submit copies of contracts, invoices, receipts, etc. by February 2. On another note, Commissioner Ellis and DA Willis have recently been at odds over the notorious condition of the Fulton County Jail. Fulton County recently allocated $75 million in federal pandemic aid for DA Fani Willis to resolve the problems with the jail. The commissioner stated at a meeting that people are pissed of the level of results or lack thereof. In an exclusive interview with Atlanta News First, Willis said the commission is using her office as a scapegoat for the county's inaction involving the jail and other parts of the criminal justice system, long before she took office. Atlanta First News reported Willis as saying, "Commissioner Ellis is not a supporter of criminal justice, is ignorant, doesn't know what he's talking about most days." For more information regarding the Fulton County Jail, see the HAC report in our video. Fani Willis blasts her accusers. We will look at the next development, the unsealing of the divorce case. Cobb County Superior Court Judge Henry Thompson ordered the divorce case of Nathan Wade and Jocelyn Wade be unsealed. Let's listen at attorney Ashley Merchant as she argues for this action.
Thank you. Judge, Rule 24 says that there's a very specific process that has to be followed for an order sealing a record. It wasn't followed in this case. It was assigned to a previous judge, Judge Angela Brown, who entered a consent order under Rule 21, granting the seal in this case. It's our understanding from emails with counsel that Mrs. Wade's lawyers do not object to that seal order being lifted. I believe Mr. Wade's lawyers do, but we believe that it should be reversed and should be lifted because it was held without a hearing. It was held, as far as I understand, without a motion, and I can't guarantee that because I don't have access to those earlier records in the case because they are sealed. But it appears it was held, it was filed without an actual court hearing where the public was allowed to be present, and so that's in violation of Rule 21. There's very specific and stringent processes that the court must follow before a record is withheld from the public, and they were not followed in this case, Judge. The first is the motion, the second is a hearing, the third is that whoever wants it sealed has to identify specific parts of the court's file that need to be sealed. Also has to delineate the nature and the duration of the seal. None of that was done in this case. And the fourth, which is the most important part of it, is the analysis that the court has to do. And what the law says in the seminal case is Atlanta Journal versus Long, which we cited in our motion, that an order limiting access shall not be granted except upon a finding of harm otherwise resulting to the privacy of the person in interest, and that harm clearly outweighs the public interest. In this case, Judge, there's been no allegations of harm that clearly outweigh the public interest. And so the first thing to consider is whether or not that order needs to be reversed. And it's our position that it does because it doesn't follow the law. Second, getting to whether or not an order should actually be entered now sealing this, we do not believe that an order should be sealed.
Has anyone filed one?
No one has filed one. So if you reverse the order at that point, if someone files it, then we can litigate that. But just focusing on the reversal of the prior order, Judge, I think the law is clear that it should be reversed because none of those findings were made and the public didn't have an opportunity to be heard.
The third development, Fani Willis Protective Motion.
It says the person seeking the protective order had unique personal knowledge of one or more matters relevant to the subject matter. We know she did. She put it in her pleading. We also know that she did because although she asserted falsehoods in her pleading, we asserted facts in our response. And those facts, even the ones we've just shown, clearly demonstrate that she's got some unique personal knowledge in this case. But more than that, we're not seeking her deposition as the district attorney of Fulton County. We're seeking her deposition in her individual capacity as the alleged paramour of my client's husband. So whatever her job is has nothing to do with whether or not she should have to sit for this deposition. I'm sure that it's inconvenient. It's inconvenient for all of us. However, I have questions, and she needs to answer them.
The judge makes a decision.
After I hear what Mr. Wade has to say, do I think I can make a determination of whether the proposed opponent has any unique knowledge about these issues? Because once again, this is a math problem and that we need to find a solution to. So, with all that being said, I'm not prepared, Mr. Axum, to grant your protective order, but since the deposition is set for tomorrow and our first evidentiary hearing is set for the 31st, I will issue a stay. And I will stay the deposition until I'm in a better position to make a determination of whether the proposed opponent would have any unique knowledge, unique being the key word there, that is not possessed by Mr. Wade himself. Now, if there's not anything else, I need to seat a jury in a criminal case.
Well, that's it. A lot has been accomplished today. It is really unfortunate that those who govern Fulton County and the state of Georgia have allowed such activities stemming from the Fulton County Justice Complex and its system to cause all this chaos, pain, even death. Fostered through lies, deception, greed, and who knows what else. This brings our video to a close. Please like the video, subscribe to King Channel TV, and click that notification bell. Peace.